Welcome to Governance Bites. I'm Mark Benicevic, and today it's my pleasure to spend some more time with Nick Summerfield. Hi, Nick.
Hi, Mark. How are you?
Good. Thank you very much for your time again today.
My pleasure.
So Nick's a partner at Anthony Harper, a law firm here in New Zealand, and a specialist in financial services. He's also had some experience on the school board, which you've said you really enjoy, which is great. And what we'd like to talk about a little bit more is directors' duties. So Nick and I caught up a little while ago and we talked about Section 131, which is acting in good faith in the best interests of the company. And that's not the only duty of directors in the Companies Act or in fact in legislation broadly. So today we want to talk about the other duties that are in the Act. So Nick, maybe you could open up with a little bit of an overview of the other duties that are in the Act.
Yeah, thanks, Mark, and good morning, afternoon, evening, everyone. So there are a pretty extensive range of duties that apply to directors. As you said, we talked before about the duty to act in good faith in the best interests of the company. Two of the other most significant duties in my mind are duty not to trade recklessly, and a duty not to incur obligations that a company can't meet. So for these two duties here, you're kind of talking about when a company's getting up to the brink, or there's a risk of it getting up towards the brink in terms of solvency and so on, related duties.
Yes.
And beyond that, there are other duties in the Companies Act that tend to deal with slightly more administrative things. There's a duty, for example, to comply with the Act and the company's constitution.
Bit of a no-brainer, that one, isn't it?
Well, exactly right.
Yeah,
look, a lot of the directors' duties are. That's the really interesting thing about it. And then, as you said, you move beyond the Companies Act, and directors are subject to a range of duties and various other legislation in New Zealand. I think of the Health and Safety at Work Act, for example, is probably the most significant one for our sector. Financial Markets Conduct Act imposes some duties on directors, right, depending on the type of entity. And then beyond that, obviously, there's other legislation, Privacy sort of similar effect. Yeah, Privacy Act is a good one. Yeah. And then you move beyond that and think about, well, duties directors might have under the constitution of the company, under a company's banking facility documents or other contractual commitments, yes, that directors make. But they kind of all come back, I guess, particularly in terms of some of those operational covenants, I guess, to that concept of reckless trading and incurring obligations that companies can't meet, which I guess is really where the rubber hits the road, so to speak.
Yes.
Yeah.
So let's dig into those two duties in particular a little bit more then. Can you expand a little bit on reckless trading and contracting in a way that the company can commit to those contracts, how they're different and what it all means?
Yeah, so reckless trading is agreeing or causing or allowing the company to carry on its business in a way that's likely to create a substantial risk of serious loss to its creditors. Right. So that's when you're sitting there and going, well, she'll be right. Yeah. We'll sign this contract, we'll enter into this transaction, we'll do this thing, when really you're at the point where you're not in a position to do so. And that, I guess, is similar to the duty not to incur obligations the company can't meet. They are quite related.
That one's probably a little bit broader, I would think, because the reckless trading one implies it's quite financial, so being able to pay all of the other creditors that you've already contracted to before engaging new obligations, whereas that one possibly might be a little bit more around, as well as the financial obligations, can you actually fulfill the contract?
Yeah, for sure. And actually that's a very good way to look at it. I think you're looking there about obligations where you may not be able to perform them when due. Yeah.
Yeah, if you're a plumber, don't contract to build a house.
Well, yes. Yeah, that's right. Good advice, Mark. Yeah.
Now, there are a couple of other duties as well in the Act, right? There's the one around if the company is moving towards insolvency, then there's the exception around acting in the best interest of the company to act to be able to pay your employees, and that issue of insolvency over and above the creditors, isn't it?
Yeah, employees do have a preference, I think, on insolvency, which I guess reflects their role. We've seen that, well, certainly recently when this was filmed in terms of the Soupy grocery business. I think ultimately someone else stepped in to pay those employees, which was a pretty awesome news story.
Right.
But yeah, I mean, there's quite a range of duties.
It's around the legal priority in that instance of who gets paid first if the company goes insolvent, right? So employees, and then you have secured creditors, and then unsecured creditors, and then eventually shareholders.
Yeah, well, shareholders certainly come last, and that's right. There is a hierarchy in terms of who gets paid. Yeah,
and as you've said, we could talk a little bit about the legislation that may be specific to the industry that the entity is operating in. And for us, of course, financial services, we've got the Financial Markets Conduct Act, and of course, off the back of many of these acts, you've also got the regulations that kind of put the meat on the flesh on the bones, right? So the higher level duties are in the act, but then the regulations will have a little bit more detail about what's required.
Yeah, that's certainly true, and everyone in the sector will know that it's an area with a lot of regulation, a lot of rules that directors need to be on top of. A little bit of risk involved in that. It's certainly, at times a challenging sector to operate in.
So if you're coming in as a director, where would you look? What would you do to find out what all these duties and obligations are?
Yeah, good question. There is some good guidance out there. The Institute of Directors in New Zealand, for example, is a really good body which provides guidance on the duties of directors. Mm-hmm. If you're looking at sector-specific stuff, you can get a little bit of guidance out of the Financial Markets Authority and the other regulators as to what directors should and shouldn't be doing. Yes. Lawyers, obviously, a slight plug, are good at giving guidance on, what directors should and shouldn't be thinking about.
There's also some great content on business.govt.nz. Even the Companies Office website, companies.govt.nz, have got some great information for directors too. So, do your Google searches first and find out that broad information. And then when you're getting a little bit specific about the stuff in your industry, go to your industry groups and find that stuff. And then ultimately, seek some legal advice if there's anything you're unsure about, and get some training. Go to a body such as the Institute of Directors and learn a bit more about your obligations.
Yeah, I'd agree with that. And if you're looking to get into a governance role, then start small. You mentioned school board stuff, which is obviously totally unrelated to the sector, but doing something like that, or getting involved in governance level at a sports club or something that you personally are really into, is a really good way to get a bit of a sort of a trial run at what governance means, and what you can do.
I would add to that, do your due diligence. Not every board that you will come into, particularly amateur boards, really have the right skill sets. So you might go in there and find that you're in a rather dangerous situation, really. So you whatever board you're going into, I'd just say make sure that there are some experienced directors on the board that understand the stuff that you can learn from, rather than a bunch of well-meaning amateurs that are kind of plodding along and hoping for the best.
Yeah, for sure. And there's a real difference between governance and management, which I imagine you've covered in other other interviews. We won't talk about that today, but you're right.
Yeah. Now we've spoken in our previous conversation around the liability of directors, particularly under the Companies Act, of for egregious stuff. There were up to 5 years imprisonment. For the civil liability, larger damages and so forth. Does that vary in some of the other legislation that we've been talking about, the Privacy Act, the Health and Safety at Work Act? Is any of that more extreme than that 5 years imprisonment? Orders, is it that kind of the upper limit of what you could be on the hook for?
No, look, it can get worse, but I think that 5 years is a pretty good indicator of the type of consequences. Some of our legislation is quite rightly set some very serious penalties. Health and Safety at Work Act is a great example of that. But you're really talking about the particularly bad conduct to find yourself in that type of position, certainly on the criminal liability side. I mean, yes, we've seen in Mainzeal, for example, which probably...
Tell us a bit more about that case.
Mainzeal is a great example, actually, of the potential consequences of failing to comply with those obligations around trading recklessly and so on that I mentioned. So Mainzeal, very high profile decision earlier this year of the Supreme Court. Very large award of damages against the directors, which included an ex-Prime Minister, for failing to meet, those duties that we've talked about. Very significant penalties, civil rather than criminal. But yeah, great is the wrong word, but a really significant precedent and a good case study that I'd actually encourage people to go away and do a bit of reading about.
Do you know what the magnitude of the damages was?
My recollection is we're talking 40 million or similar, but
across the directors.
Yeah, but I'd have to.
It's quite significant, right?
It's a very large sum of money. Yeah, that's right.
Yeah, right. And of course,
that
Mainzell was quite a large company, so you're talking at the listed end of companies.
Oh yeah, very significant in undertaking, and the size of the damages reflected that. But that's a pretty big shot across the bow. So
it certainly seems that as you say, it's really rewarding getting into the governance space and helping entities, whatever they may be, to identify their purpose and meet their objectives and do more of what they want to do.
Yeah.
Don't do it lightly. Make sure that you go in with your eyes open, you understand what your obligations are so that you can do the job well, because it's not something you want to go in and do a half-cocked job in.
No, I agree, and there's nothing worse really than going into a role like that and not giving it your all. That's when you will get in trouble with those directors' duties. If you're talking about a company, you're there responsible for everything that happens, or for overseeing everything that happens, and you need to be have an understanding of all aspects of the business. That means, as an example, understanding the financial matters, even if you're not an accountant. You can't simply say, no, that's not my thing, it's not my problem, because you're a director. You are responsible. Right,
so you've got to get that broad business understanding to be able to do the job effectively.
Yeah, I mean, you do, and we talked about this in our last interview, you do have the ability to rely on others in some circumstances,
yes.
But that's not I didn't know, I didn't care, it wasn't my problem defence. That's something you really have to test the people on. You have to have an understanding of all aspects of the business, and certainly, the courts have been very clear in respect of financial matters that is the whole board's responsibility.
And your advice to new directors last time was very much around asking questions on that basis, right? So get in there and if you don't understand something, ask about it, ask questions, and don't just sit there and be a passive seat on the board.
Yeah, for sure. Yeah,
great, thank you. So now, of course, the duties around directors will be, or particularly in the legal space, will differ from country to country, from jurisdiction to jurisdiction. We've been talking very much about New Zealand law here. The principles of governance, I think, are very similar around the world, but of course those verbatim duties will differ from country to country because they're all based in law, right?
Yeah, that's right. And there's no doubt that's true. I come back to those principles. I think, I can't speak for every country, of course, but my experience in most countries as well, they kind of deal with the same types of issues in a broadly similar way. When we're talking about principles of directorship, then certainly.
There's unlikely to be a country in the world that says do what you want for yourself. It's generally going to be about acting for the entity, and it'll be variations about what acting for the entity means in terms of acting for other stakeholders and how that fits in. So there are some differences, particularly in Europe, for example. They've got some differences where they can be a little bit broader around other stakeholders, right?
Yeah, that's right. Yeah, that's exactly right. Sort of the principles are there, the detail may differ, the process may differ, but you're kind of trying to do broadly the same thing.
Okay. Yeah. So what's the best advice that you've received in this kind of space?
Well, I think, I think the first piece of advice I really like is to remember that a well-functioning board is one where everyone is involved, where everyone, you don't have to be best mates, but you have to get along, you have to be collegial, you have to have a good working relationship, you have to value everyone's input, and deliver as a team, have those hard conversations if you have to, but really work together as a group, and that's certainly how you get the best results as a group. Yeah,
right, absolutely. And I think one of the other things you were saying, you've got to be collegial. If you all get along too well, you may be too similar and you may have a bit of groupthink going on there. So, you should be challenged on the board. You should have people that think a different way from you, that make you feel a little bit uncomfortable. That's important.
Yeah.
And you've got to be professional with those people and, as you say, collegial with those people to have a good working relationship to get the best outcomes for the entity. Yeah,
I totally agree. I think, most stuff in the sector, there's no one right answer. You get different perspectives that influence your view and that challenge you if that's what needs to happen. If you need to be challenged, great. And then you'll come together and, come up with an answer or a path forward which is better than the sum of the individuals. Yep.
Great. Okay, so Nick, thank you very much again for your time today. It's been really cool to catch up again. I'll look forward to seeing you soon and catch up with you next episode.
Thank you. Thanks, Matt.